Ladies and gentlemen, welcome back to Gambling Savant. We have breaking news regarding the SEC versus Ripple lawsuit. I'm going to play you a video clip. It's about 5 minutes long, so hang in there with me. But it is coming from attorney Jeremy Hogan, whose channel is Legal Briefs. And I've been following him exclusively regarding this matter. He does a great job of breaking down and articulating any and all details regarding this case. So, let's get right into it.
I thought that the SEC's description of the case was pretty vanilla. I've only really had a chance to read it one time through, but I was a little bit surprised that they were they didn't really provide a lot of facts, and I'm going to give you some examples here. So on page 2 of the letter, which is the first full paragraph, it says, first, the complaint alleges that the defendants violated sections 5A and 5C of the Securities Act. And then the most interesting paragraph in here, I think, is the second full paragraph. The complaint further alleges that defendants sold XRP as investment contracts under the Howey line of cases, primarily because the economic reality of XRP and the way defendants marketed XRP made a purchase of XRP in exchange for cash or other consideration and investment in a common enterprise. So here they're talking about the heart of their case, really. This is it. Was there an investment contract or not? And what do I see when I read this paragraph? There are no facts. So it's really weak. It's all conclusory. They should have at least included, they have some facts, because I remember it from the complaint, but none of them are in here. And I think this is kind of a weak statement as far as a first statement to the judge. Next, the SEC addresses the defendant's defense in this case, and that is on page 2 at the bottom, the last paragraph, where they say, quote, defendant's principal response to these allegations is to affix a self-serving label to XRP, quote, currency, close quote. Now, it's good to address your opponent's defenses in a lawsuit, but this is a very weak defense, if it is a defense at all. The fact that Ripple calls XRP a currency is not the heart of its defense. And the SEC spends 1, 2, 3, 4 paragraphs of this is very pricey real estate in a 9-page letter. They're only allowed really 3 pages here to give their side of the case. They spend like a whole page just talking about that Ripple has called XRP a currency, and this is just a red herring. I think it's really misplaced time in their letter to the judge. This is the case. This is the time where they get to make their case to the judge, and they spend 3 or 4 paragraphs talking about what Ripple used to call XRP. And my response to that would be, really, it doesn't matter. A security is a security no matter what you call it. That's the heart of the Howey test. And here the SEC wastes so much time talking about what Ripple used to call XRP, currency, not currency. It doesn't matter to me. It really doesn't matter. And I think it's not going to matter to the judge either. So this is just wasted real estate. Okay, let's go to page 4 of 9. This is where Ripple gets to lay out its defenses to the judge for the very first time. And I think they did a really good job, much better than I expected. Actually, I'm very impressed by what they put in the letter. So first off, let's start at the top of page 4, Ripple's description of its defenses. In talking about whether XRP is an investment contract, Ripple keeps it simple. Quote, they are not. XRP is a digital currency like Bitcoin and Ether, 2 other digital assets that the SEC has concluded are not securities. I like the fact that they put that in there. Now going down to the 3rd paragraph where it says, first, XRP is a digital currency or asset. The SEC's allegations that Ripple sales of XRP constituted investment contracts lacks any legal or factual basis. So basically they're calling out the SEC for not having any facts in its position statement. The evidence will show that Ripple has sold XRP as an asset with no promise of future services or profits. To call such sales investment contracts distorts the statutory language beyond recognition. Indeed, in many instances, the people who bought XRP did not even know that Ripple was the seller, because there were sellers of XRP other than the defendants, and open market XRP sales are generally anonymous. So I think that's a great point, that after Ripple sold XRP, it was then sold downstream. So how can it then be an investment contract?
All right, everybody. That gives you some insight and some factual data regarding this case. So basically, in a nutshell, Judge Torres wanted a first statement from both parties to give a brief description of the case and factual and legal basis for their claims and defenses. Jeremy Hogan's saying that the SEC's complaint is very weak and it's not based on detailed facts, which I totally agree with. in a general timeline of what we're looking at here. So we've got the first pretrial hearing next Monday, February 22nd. July 2nd of 2021, fact discovery has to be completed. August 16th of 2021, all expert discovery shall be completed as well. The last date for discovery then moves into a motion of judgment. And the hearing, they expect to take place sometime in October if things escalate to that. So, really, what I'm taking away from this personally is one name, and that's Gary Gensler. I believe that once he becomes head of the SEC, chairman, that's when we'll find a way to resolve this case and come to a settlement agreement. Currently there's no prospect for settlement. We're dealing with the previous administration at this point, and Gary Gensler being the crypto expert, it would only make sense to get him in office and be a rational crypto thinker and come to an agreement with all the details related to this case. So that's about it. Just wanted to give you a quick update. I will definitely be bringing more information to you when it gets released, especially relating to legal briefs and Jeremy Hogan. So that is all for today. If you like this content, please like and subscribe. Comment down below. I'd love to hear from you. And I will leave you with a quote from David Osmond. It is as follows: "To know everything everyone else knows is clever. To know one thing no one else knows is genius." Thank you for tuning in, everybody. Have a great day, and I'll talk with you a little later.